Hello everyone and welcome back. In this video I am going to talk to you about what happens if you are the respondent in a Marchman Act case. So the last couple of days we have had a bunch of calls from people who have been Marchman Acted, and my staff in our intake department are trained to ask you and will ask you at what stage of the proceeding are you at. And that's important because obviously if the court has already entered an order for treatment services, that might change what we can or cannot do for you. So let's back up a little bit and just sort of remind everybody that there are two steps to the Marchman Act process. Even though it's one filing now as opposed to two, which is what it was before the changes in 2024, there are two stages, two steps. Number one is the assessment, and number two is treatment. So the court is going to review the request for an order for assessment, whether it's filed on an emergency ex parte basis or you are requesting a hearing for the assessment, and the court may or may not enter an order for assessment. But if it does, I kind of want to know, did you go for the assessment? What are the results? What does the assessment recommend, if anything? We are still at the point where we can probably challenge the findings of the assessment and decide, is the assessment valid? Is there another option? What do we do if you would like to go to treatment, but there are some things that could be done? But if you have already been in front of a judge and the court has made a determination that you meet criteria for the entry of an order for treatment services, meaning you have been ordered to go into treatment, you're going to need to comply with that order, because if you don't, you're probably going to find yourself on the receiving end of a little bit of time in the county jail. That is what can happen if you don't comply with the order. But if you've been ordered into treatment, is there another option? Could we get you moved into another appropriate treatment center? Perhaps you don't like where you are. Perhaps you don't feel like it's a good fit for you. There are some things that we can do. But if the court has already entered an order for treatment services, as a general rule, and remember, nothing is, I want to give you guys the sort of 10,000 foot overview. That doesn't mean to say that we couldn't help you in your case, but as a general rule, if an order has been entered for treatment services, you're going to need to comply with that order, and I cannot unring that bell. That train has already left the station. You had a hearing, and I get it. Some people call and say, well, it wasn't a fair hearing, I didn't have a lawyer. I get it. But if you have had a hearing and a judge has entered an order sending you to treatment, you need to comply with that order. Okay, I will never tell you that you shouldn't comply with an order. In fact, my team will tell you, you better comply with the order. Okay, compliance with a court order is not optional. You gotta go. Whether or not we can change the treatment center, again, something for a different day. But if you are the Marchman Act, if you've been Marchman Acted and you are the respondent and you want to have a conversation about what we can or cannot do for you, feel free to reach out to you. We are here to help. And if you've been Marchman Acted and you want to go to treatment, but you'd like to choose where you go, I can help you with that too. Okay, we have lots of great facilities we work with. I have plenty of resources we can make available to you. And if you just want to know the name of a couple of treatment centers, there's no charge for that. I'm happy to give it to you for free. So with that said, I would appreciate a thumbs up, and if you could subscribe to the channel, that'd be great too. Thanks for tuning in. See you in the next video. Bye-bye.